Sorry. Is that better? Thanks. Our planning committee for this program is Gretchen Timmins and Tom Wright. Gretchen was called to the bar in 1983. She practices with the firm of Miller Thompson in Toronto, and her practice is primarily restricted to family law. Gretchen is the secretary of the Family Law Section Executive of the CBAO. She's a speaker to various groups in connection with family law, including dinner meetings of the Family Law Section of the CBAO. Tom Wright is the senior solicitor to the Support and Custody Enforcement Branch since April of 1986. He was called to the bar in 1975 and is a graduate of Queen's Law School. Tom was in private practice until joining the government in October 1985, and he practiced in Kincardine, Ontario, with particular emphasis on family law. Tom has been involved from the outset in the implementation of the Support and Custody Enforcement Branch. Our first speaker this afternoon is Gail Taylor, who is the director of the Support and Custody Enforcement Branch. Ms. Taylor joined the Ontario government in 1980 after 7 years as a project manager and field officer with the federal government and Canada Mortgage and Housing Corporation. She was previously the Director of Operations Review and Audit for the Ministry of Housing and the Ministry of Municipal Affairs since 1985, and she was appointed the Director of the Support and Custody Enforcement Branch in November 1986. In this post, she has thoroughly enjoyed joining a strong management team and helping build the organization to launch and administer the program. Ms. Taylor holds a Bachelor of Science degree in Mathematics and an MA in Social Policy from McMaster University. And I'll now turn the program over to our first speaker, Gail Taylor. Thank you very much.
Thank you. Is this working? No. Is this working? I'm going to hold it as a mic. Thank you, Yvonne. Thank you very much. From the introduction, as you know, I'm more a person of numbers than of letters. We're very pleased to be here at a continuing education seminar that features as your sole agenda item the administration of the Support and Custody Orders Enforcement Act. And the organization set up in July of 1987 to deliver the program and indeed how we operate. It's important for the effectiveness of this new program that we work well with the family law bar, local bar in each of our regional areas. We want to hear your questions, your concerns, your ideas. In a sense, they are a barometer to us about how we can communicate effectively with the public about this new program. And at the same time, it's a chance for us to explain our operations so that you as lawyers know how to use the office and what to tell your clients. Well, establishing this operation was indeed a major undertaking requiring rather sophisticated teamwork from many professionals, computer professionals, lawyers, accountants, court staff, other ministries, management board, not to say the least Treasury, those who hold the keys to the coffers. In my paper, I cover a bit about the rationale for the program, highlights of our mandate, the keys to success that we learned from other jurisdictions carrying out similar programs, the computerized monitoring system set up to deliver the program, and the operation and makeup of the offices, and a bit about what we hope to accomplish. Well, I guess it's well known that the degree of compliance with support orders in many jurisdictions, indeed for many years, has not been very good. In 1974, the Law Reform Commission of Canada did a Canada-wide study showing that something like 75% of support orders were in some degree of default. We looked at a number of things, including research done by Frida Steele and published in 1986 that showed the rate was anywhere from 65 to 85% of all orders in default. In a field test that we ourselves conducted on our computer system in February of this year, we found that well over half of the orders that were making some kind of payment during the month of February were in default to some degree. We also found that a large percentage of these orders involve children. So that indeed we're talking about a children's issue. On average, we had about 1.8 dependents or children per order. As Frida Steele has said, a system of justice that fails to achieve its objective more than 50% of the time is unacceptable. At the same time, there's been a large cost to support recipients of bearing the burden of enforcing on their own. And we know that many single-parent families are mother-led, and in fact it's been claimed that something like 1 in 5 children in Canada, therefore, is growing up poor. Therefore, it was felt there was a need for some rather unusual measures to address this type of judgment debt. And as you know, Bill 14 in the last administration, was passed in November 14, 1985. And the act was proclaimed in July 2nd of this year. Well, the purpose of the program is about individual responsibility. It's about our responsibility to honor custody provisions and fulfill our support obligations to our family members. Our job is to ensure that support and custody orders are honored as a social imperative. The actual procedures and operations are outlined in later papers, but I can say just generally that our agency is set up to monitor, receive, and disperse support payments and enforce orders when they fall into noncompliance. Our goal, therefore, is to facilitate a steady stream of income on a larger number of cases than has been experienced in the past. When we began to develop the program, we looked at other jurisdictions, notably Manitoba and Alberta. Manitoba because they've had a program since 1980. Alberta's is about 18 months old. We also talked to family court office staff and the systems in place in our family court system. We looked at the current research, we talked to family law practitioners, and we looked at other ministries and related sorts of businesses. And what they told us was that there are 3 or 4 keys to success. One is that you must have accurate financial, up-to-date information to enforce effectively. And furthermore, it's humanly impossible to scan through literally thousands of ledger cards manually and gain up-to-date, instant financial information. So it was necessary to automate, to use a computer, to log the accounts and bring reports forward quickly. It's also necessary to have legislation that gave us tracing and information link possibilities, and staff will talk later about that. Also important to have automatic state-initiated enforcement. In other words, we take onto our shoulders the burden of enforcement rather than the individual having to initiate the enforcement. And last, of course, an effective operation, an effective organization with specially trained staff, with skill in tracing and locating, and with the systems to promptly react to default. We have developed what we think is a modern, state-of-the-art computer system that produces a listing of accounts in default immediately if asked for within 5 working days generally. It has the ability to scan the thousands of accounts. It covers daily posting to current accounts online, and overnight it posts to accounts and then the next day disperses checks which we send out to the support recipient. It also produces a statement of arrears or a statement of account and many letters and forms that go to the parties to an order. We also have links with OHIP at the Ministry of Health by tape over a weekly basis, and with the Ministry of Transportation and Communications in literally 20 seconds. And eventually we're looking at enhancements to the system to include automation of some of our documents, such as garnishment requests. The operation of the program is based in 8 field offices in the major urban areas of the province. Organizationally, we're separate from the court administration offices, and the benefit of that is that we're dedicated to one function instead of carrying out many duties for the court. We have the automated accounting system I mentioned, and we are divided into basically 3 components in each office: an accounting side, the enforcement clerk component, and the legal. The accounting side does the banking and the cash management using the computer. Our statutory enforcement officers take the enforcement decisions, prepare the documents under the direction of a regional manager and a regional solicitor. Now, the backgrounds of people in management and at the clerical area encompass experience in collections, in banking, accounting, court administration, policing, retail, investing, and many other related backgrounds. We also have a legal component. It's rather unusual to have staff solicitors to a program in the Government of Ontario. Speaking from a management point of view, we are exceptionally pleased with the lawyers we have working with us. They bring solid professional backgrounds and fine judgment to a challenging task under the functional leadership of Tom Wright. They have anywhere from 3 to 6 years experience in family law practice and also some in the collections area. In the paper, we talk a bit about the benefits of the program and what we hope to accomplish. One of the things that the computer will be able to produce will be a year-end financial statement for support providers at the end of the year. We feel we're removing the transaction, the financial transaction, from two parties who may still bear some unresolved hostility to one another. Ultimately, we hope that public attitudes will change, that support orders and custody provisions will become a regular habit and a priority like any other debt. And what we're all about is ensuring responsible behavior to the benefit of the children involved, estimated to be something like a little over 100,000 children involved in orders during the first year of our program. And in general, in the long run, there'll be a beneficial impact on social assistance enrollments and other support systems necessary to help single-parent families. Ultimately, we hope there'll be a renewed respect for this system of justice surrounding this component of family law. I'm pleased now to hand over to Tom to the main part of the program because I know you're concerned about the legislative tools and the legal procedures used by our program to discharge our mandate. Thank you.
Good afternoon. During my private practice days, particularly as a sole practitioner with a general practice, I often had paused to stop and think between phone calls from people who were either saying, "Why aren't you doing this?" or "Why did you do it?" how nice it would be to specialize in one area of law. And not only one area of law, but perhaps one act. So much the better. Well, my dreams, if you can describe them as that, came true. I became senior solicitor to the Support and Custody Enforcement Branch. The unfortunate reality is that support and custody enforcement, at last count, we've been able to track some 40 different pieces of legislation, both acts, regulations, etc., other things that are hidden that unless you look for it, you never think to find. And I'm now involved in looking at things such as the Income Tax Act, which I never looked at before in general practice. I'm looking at things called Garnishment, Attachment, and Pension Diversion Act, and heaven forbid things such as the Creditors Relief Act. Well, today I'm going to talk to you only about the hub, if you will, of the enforcement branch, which is the Support and Custody Orders Enforcement Act, what we affectionately refer to as SCOE. There's a copy of the bill that is at the end of the material that you have today. I'm pleased to see that it's there because if you were to buy the office consolidation, the little blue that the Ontario Government Bookstore provides, it stops at section 14 and does not reproduce the 3 or 4 additional sections that were part of the Act. These sections are amendments to other legislation and are extremely important. I now know that the little warning or rider that they put on the office consolidation that says this is a matter of reference only, please refer to the original legislation, I understand now why it's there. The miscellaneous amendments are not shown. I'll refer to them, however, this afternoon. By way of introduction, it need hardly be said that this legislation applies to the enforcement of all support and custody orders, whether or not the order is filed with the office of the director. It's an act of general application. Secondly, I'd like to mention to you that throughout the afternoon you're going to hear words creditor and debtor. If you look through the act, those words do not appear. However, their meaning is very simple. The creditor is the person who is to receive the support payment. The debtor is the person who has the support obligation and is in fact to be making the payment. The act itself has been proclaimed in two parts. Approximately one half were proclaimed in March of 1986. The balance of the legislation was proclaimed, as Gail has mentioned, on July 2nd of 1987. The only section of the act that now remains unproclaimed is subsection 3 sub 5. That section or subsection deals with orders that were presently filed for enforcement with the family court automatically being filed with the director's office as at July 2nd. That section has not been proclaimed, and as a result, persons with orders that fall within that category are required to file voluntarily with the director's office. The branch does operate from 6 regional offices and 2 sub-offices. Those offices are listed together with names and addresses in both the filing package, which you have handed to you today, as well as in the brochure. Attached to the paper that's prepared for this program, you will also see the list of offices together with addresses and toll-free numbers, as well as a list of the family courts that come within each of the regional office locations. That's at the end of the materials. Turning to the act itself, the Director of Support and Custody Enforcement is a statutory position as established in subsection 2.1. This statutory authority has the duty to enforce support and custody orders that are filed with the director's office. That is one of the most significant features as far as lawyers are concerned and as far as the director's office. It's not all support and custody orders that the director enforces. It is only those orders that are filed with the director, and it is only when they have been filed with the director that the director may in fact act and enforce that order. The authority and duty of the director contains what could be described as an item of discretion. The words used in particular are in the manner, if any, that appears practical. Those words would appear to apply to the method of enforcement that the director may choose to follow as far as a particular order is concerned. As well, this discretion would appear to allow the director the ability to choose not to enforce in certain very limited circumstances, such as cases where the provision that's being enforced is unclear, or in the case of a custody order, perhaps where the best interests of the child are in fact an issue, and that is a consideration that has to be taken into account. This duty to enforce is enhanced by the fact that the Act allows the director in subsection 2.2 to take steps to enforce in the director's name. The director does this for the benefit of the person for whom the order is being enforced. As a result, what you now have is a new statutory litigant, and what you will now see are enforcement actions being taken in the following style. The Director of Support and Custody Enforcement for the benefit of. After the of comes the name of the person for whom the order is being enforced. So notwithstanding what your original style or title may have been, there will now be an additional style, if you will, in the form of the director. This authority to act in the director or for the director permits the director to take steps without the direct involvement of the creditor, in the sense that the creditor does not have to come in and sign documents such as a request for garnishment or a request for a writ of seizure and sale. Notwithstanding the fact that the act was proclaimed on July 2nd, the director is given the express authority to enforce arrears of support that accumulated prior to July 2nd, 1987. That's contained in subsection 2.3 of the Act. It's interesting to note, and it's certainly a matter that has come up, the duty of the director does relate to enforcement. It does not relate to variation. The director does not represent, that's the correct word, the creditor should an issue on variation come up. The other point that it identifies is if you are bringing a variation application on behalf of a debtor and the order is filed with the director, I would strongly suggest that if you are seeking a stay of enforcement, that you would be wise to join the director as a party in that variation for purposes only of the stay relief. Otherwise, you may find that the director doesn't know that a variation is in fact pending and would be, without that knowledge, continuing to enforce. The Act contains an extensive definition of support order. It is clearly an extended definition. It's contained in subsection 1.1. And the initial words are these: a provision in an order made in or outside Ontario and enforceable in Ontario for the payment of money as support or maintenance. Suggested that the primary definition stops at that point, and the enumerated provisions are in fact a further, if you will, additional type of support order. You will see that they include some of what would be considered to be non-traditional items of support, such as exclusive possession, as well as incidents such as payment of monies relating to exclusive possession. The definition of support order by inference, although it doesn't say, I think clearly indicates that interim orders or orders made on a variation application would also be considered to be support orders. As well, agreements in the form of separation agreements, marriage contracts, cohabitation agreements, when they've been filed previously pursuant to Section 35 of FLA 86, can also then be filed with the director and enforced as a support order. The one exception that is apparent from the definition is provisional orders not being involved simply because they have no force and effect until such time as they are confirmed. The second definition that does appear is custody order. It's defined again as an order of a court in or outside Ontario, enforceable in Ontario for custody of a child, but not for access to a child. So that we have a situation where the ability of the director's office under this legislation, or anyone else under this legislation, that the definition of custody order clearly distinguishes access. Access is not included and is not enforced by the director's office. The issue of access is being dealt with separately by other legislation which purportedly will be amending the Children's Law Reform Act. Mentioned earlier, filing with the director. What does that involve? It can basically happen in two ways for support orders, and one way only as far as custody orders. You may note in the legislation that subsection 1(2) allows a lawyer to file a support or custody provision on behalf of a client. If you were to have instructions from your client, then the lawyer can in fact ensure that the filing with the director is completed. The automatic filing of support orders applies only to orders made after July 2nd, 1987. Subsection 3(3) of the Act provides that every support order made by a court in Ontario on or after July 2nd, 1987 will be automatically filed with the director by the clerk or registrar of the court that made the order. That is how those types of orders come to the director's office. It is an automatic filing. The important thing to remember is that that filing cannot take place until such time as the order has been signed. So notwithstanding the fact that the order was granted, until it's actually been taken out, it will not be automatically filed with the director's office. There is a suggested wording included in the materials for the type of clause that should be going in these types of orders after July 2nd. The second way for orders to come to the director's office is simply voluntarily. Section 3(1) allows a person who's entitled to support or custody pursuant to the order, or by a parent of a child entitled to support under it, to file the order with the director. It appears that this wording allows for the situation for the person who is to pay support to in fact file the order. The actual process of filing in terms of voluntary orders will be dealt with otherwise. It's a very simple procedure. It can either be mailed together with the filing package, or it can in fact be taken to the regional office if that was more convenient. Custody orders are filed voluntarily only. I think we're all aware that orders that are made very often, and I'm sure in the majority of cases, will deal with support and custody at the same time. That order will be filed. The thing to remember, though, is it is only the support order that comes into the director's office. The filing package that you have shows that there is a separate form that is to be completed when the person wishes their order filed for custody. There is no automatic filing as far as custody orders are concerned. The same thing applies with respect to agreements relating to custody. All that happens is the agreement goes directly to the director's office. There is no provision contained in the Family Law Act or the Children's Law Reform Act which would be similar to FLA 86, Section 35, which applies only to support orders, to agreements containing support provisions. We now have the order filed with the director. What happens then? Well, basically what happens then is that the exclusive authority to enforce that order is now vested in the director. That's contained in Section 5. So you have a very important consideration in terms of the ability of a party or a person other than the director to enforce an order once it has been filed with the director's office. Suggested that simultaneous enforcement could not take place. In other words, the lawyer for the creditor or the creditor actually doing the enforcement while the order is filed with the director's office. The Act acknowledges the fact that someone may wish to withdraw from the director's office for whatever reason. And in fact, subsection 4.1 permits the withdrawal and sets out the procedures as far as withdrawal is concerned. The Act also allows someone who has withdrawn to refile the order at any time. The only exception that's applicable at all to this right to withdraw is when the order has been filed by the Ministry of Community and Social Services, or where there is some form of assistance involved, in which case the consent of the minister or that ministry is in fact required. When either an order is filed or withdrawn, the director's office will give notice to both the creditor and the debtor of that fact. This allows the person who, and there are certain unusual twists that will be referred to later on in terms of who can withdraw, this allows the creditor to know that the order has to be refiled because of a withdrawal by the debtor under certain circumstances. The other sections of the Act, and one in particular that comes to mind is the Section 6, which deals with access to information. The section sets up two methods, basically, available to both the director and also to the person who's enforcing on their own. There is, however, a very large distinction in terms of the availability of the section. Section or subsection 6.1 allows the director to simply write and request certain types of information. And that information is the place of employment, address, or location of the person against whom the order is being enforced. That's done by letter. If the matter is being done privately, it would in fact have to be done by way of motion to a court, and a court would have to, in essence, authorize the request for information to be made. There's a significant advantage then in terms of the director's office in getting this limited type of information. The director also, however, and this is where you as practitioners may be involved, if in fact the demand for information or request for information is refused, the director may apply to a court by motion to require that the information be released. And the significant feature for lawyers is the provision of the legislation, basically two provisions. One says if the director is successful, then the court shall award costs to the director. And the second provision is contained in subsection 6.6 is that this right of the director applies despite any other act or regulation and despite any common law rule of confidentiality. Clearly begs the question with respect to the lawyer as to whether or not if the director were to make a demand on the lawyer, whether or not the lawyer was compelled to release those limited types of information to the director. We'll refer to this later on in the course of the issue panel. There is one case, although not decided since this section was enacted, that does in fact address this issue. The Act also contains a second provision dealing with information. That's found in Section 7, which talks about, and I mentioned a number of pieces of legislation. Not only are there a large number, but they seem to have, for some reason, a compunction for long names. And this is the Family Orders and Agreements Enforcement Assistance Act. It's federal legislation. Part 1 only will deal with information. Part 2 is the interesting part because it's going to allow you to do things like seize or garnish Canada savings bond interest, income tax refunds, unemployment insurance payments, things of that nature. Sorry to say that it's not yet in force. Part 1 is also not yet in force. However, it will again provide additional means for enforcement of support and custody orders. The agreement referred to in Section 7 between the Province of Ontario and the federal government has been entered into, and basically we're ready to go as soon as the legislation is proclaimed. The latter portion of the Act, starting around Section 10, deals with really the only new remedy that this Act introduces on its own. It's new, it's useful, and I understand from various people, very effective. And what it involves is registering the support order against the land of the debtor. The particularly nice feature of that section is that you don't need arrears of support in order to register. So what you have is, if the matter was being enforced privately, if you thought it wise, you have the ability to, immediately after the order was obtained, and assuming you knew the location of land, to register that order. Basically, it sits there. It's a charge on the land. You're going to get notice. You can ensure you'll get notice from those in the conveyancing side of things, wanting you to do something with it, be it postpone it, discharge it, whatever. So you really have a remedy that can sit, tick away, and be effective at the most surprising of times. It also allows you to sell, if in fact there are arrears, to sell the land as if it were a sale under mortgage. The instructions to the land registrars and sample documents that you can use to register are contained in Land Registrar's Bulletin 87008. It's referred to in the materials. That's dated June 22, 87. Briefly, I'll move to the default hearing. One of the very basic points, certainly as far as the default hearing, which is referred to in Section 11, is that it must be held either in a family court or in a unified family court. Doesn't matter if the order is a Supreme Court order. The simple fact is the Supreme Court does not have, in the form of Section 11, the jurisdiction to, in fact, conduct a default hearing. They are all conducted either in family court or in unified family court. The director has the power to request a default hearing where there is arrears, as do people who are not filed with the director. That, in fact, is contained in subsection 11.2 with respect to a person not filed, and 11.1 as far as the director is concerned. The debtor is presumed to have the ability to pay the arrears and to make subsequent payment. It's one of the principles that exists at a default hearing. The second principle that exists, or assumption, presumption if you will, is that the director's statement of arrears is presumed to be accurate while the order is filed with the director's office. I think it's important to note that presumption applies to the period of time that the order is filed with the director's office. So if you're enforcing arrears that accrued prior to that, issues of proof may well still arise. If the court were to conclude that payments should have been made, there are 8 different types of orders that can be made, and they are very conveniently set out in subsection 11.6. They range from discharging the arrears in installments, providing security, and the ultimate remedy, I would suppose, in appropriate circumstances, would be incarceration for up to 90 days. The Act has, or does contain, a provision that clearly says that notwithstanding the fact that there was a term of imprisonment, that subsection 11.8 provides that the imprisonment does not discharge the arrears that are owing. So unlike a fine where you would have the choice of serving time, if you will, or paying, this does not extend to support orders. You, in fact, are required to pay whether or not you've spent time in jail. Support payments, when they are actually recovered, are subject to a priority. I should perhaps phrase it as subject to. I should phrase it in the positive as they have a priority. They have a priority over all other judgment debts. That's contained in Section 15 of the Support and Custody Orders Enforcement Act. And I suggest that it's a section that is not only of interest to those of us practicing family law, but I'm sure is of great interest to anyone who is in the collections business of any kind. Basically what it says is that there's a priority, no matter when the enforcement procedures are commenced, to the extent of 1 year's worth of periodic support payments that are in arrears, as well as the full amount of any lump sum that in fact may have been ordered and was in fact owing. There's an example in the paper which sets out how this might work. The bottom line is basically this: if you had a series of execution creditors, one of which happened to be a support creditor, doesn't matter when or who starts the particular type of enforcement, be it by way of seizure or else, when monies are recovered, before anyone gets anything, any of the execution creditors, the priority is going to come into play and the support creditor will recover. The sheriffs are certainly aware of this interesting new wrinkle, and it certainly is one that all of you should be aware of, because it does impact on you, not only, as I say, in family law, but if you're acting for another execution creditor considering taking action, your client may not be thrilled with the fact that you take action. In fact, we're able to seize and sell a vehicle, but because there's an execution relating to a support creditor, that person gets all the money. You may have some trouble in justifying the result, and more importantly, I suppose, in trying to justify an account when you've been so successful, but in fact have put the money in someone else's pocket. So it's something that, as I say, has a larger implication than simply in the family law setting. The last thing that I would like to touch on is unrelated to the legislation itself. The other sections of the Act are covered in the materials you have, so I've been to these programs before, and I don't want to simply repeat everything that's there. So I will, however, turn to one last issue, and that is the issue of panel lawyers. Some of you, it's hard to tell how many mail strikes we've actually had this summer, but somewhere during the month of June, we placed ads in the Ontario Reports and Lawyers Weekly concerning a panel of lawyers that was being developed to represent the director. Hopefully at some point the mails got through and you had a chance to see the ads, and if you were interested to respond. The response, mail must have got through because the response was overwhelming, certainly as it relates to 4 of our regions. And we have basically filled the panel for the time being in the cities of Toronto, London, Ottawa, and Sudbury. We are prepared certainly to entertain applications from lawyers who are located elsewhere, if I can describe it as that way, as far as the panel is concerned. There is in the paper the list of the information that we require. For those of you who are here who applied and haven't heard, please accept my personal apologies. The matter is rapidly being concluded, and I would hope that very shortly the response will be coming to you so that you do in fact know that whether or not you've been selected to the panel. I would indicate that the lawyers who are involved in representing the director will be doing a number of things relating to items such as garnishment disputes, default hearings, examinations, Children's Law Reform Act motions, and things of this type. The reason for the panel, of course, being that our regions, it's unfortunate we don't have a map for you, are very large. The Hamilton region, for example, extends all the way down to Niagara Falls, up to Cayuga area, and over to Milton in that area. So the lawyer who is on full-time staff isn't basically able to appear in all jurisdictions at the same time, and we are therefore going to be retaining counsel to represent the director in those types of areas. Thank you for your kind attention. That basically is all I have to say at this time on this particular act. Yes, I'll introduce it. The agenda indicates that the next topic is the specific issue of enforcement of support orders. We're fortunate to have with us this afternoon two people well experienced in this area. Initially, Heather Robertson. Heather was called to the bar in 1981 in private practice since her call, currently with the firm of Gowling and Henderson in Toronto. She's practicing exclusively in the matrimonial law area and is a speaker to various groups involving family law, as well as participation in continuing legal education programs with the Law Society. The second person is to my immediate left is Linda Feldman. Linda is the regional solicitor with the Support and Custody branch in Toronto. Linda is a graduate of Western LLB in 1980. She joined the branch in June of this year after practicing general litigation with a firm in Toronto since her call in 1982. Linda, Heather, thank you.
Thank you, Tom. Okay, I'm going to start off this segment of the program, and Heather will follow through. I'm sure you all have only the best of intentions of reviewing the program's materials from cover to cover when you have a free moment. And I know the sparseness of those free moments. I do hope you get to it soon. But in the meanwhile, I'll highlight a few of the points contained in my paper, which should at least serve as a stopgap measure until you've got some time to review the materials. The first area I'd like to review concerns the area of negotiating domestic contracts or framing your notices of motion, which will result in court orders. There are a few points to keep in mind which will make the enforcement staff's job easier, more effective, and your efforts less open to repercussion. Remember that Heather and I are speaking about support orders. When I say orders, I'm dealing only with support orders. And when I say domestic contracts, I'm dealing only with the provisions in those contracts concerning support. The first point to keep in mind is please avoid using global periodic support figures. Rather, please specify the quantum of support to which each support recipient is entitled. And the reason for this is that when the director receives an order or contract requiring one party to pay $600 monthly, say, for the support of 2 children, and we're told that one of the children is no longer dependent, the director is not in a position to conclude that the remaining child is necessarily worth 50% of that original amount, or $300 monthly. In your second spare moment, you might review the case of Swidzinski. That's reported at 1985, 45 RFL 2nd at page 365. The second point is that in cases where a lump sum payment or a property transfer is intended to be in lieu of or in reduction of support, please be very clear in the domestic contracts or in the relief that you're requesting for the order. Please be clear in identifying those provisions as being related to support. Again, we can enforce, or the director can enforce, orders related to support. So if you're dealing with a lump sum payment and there's argument that it may be, or we can interpret it as being, say, an equalizing payment under the FLA, then it may not be enforceable by the director. Okay, the third point is keep in mind that domestic contracts must first be filed with the provincial court or the Unified Family Court under Section 35 of the FLA, and then filed with the director's office. Then please keep in mind that under the Family Law Act, Section 34 sub 2, the provincial court cannot make certain types of support orders that the other courts might be able to make. Finally, keep in mind that when the domestic contract is filed with the provincial court, then under Section 35, it may be enforced as if it were an order of the provincial court. So the point I'm leading up to is that where there's provisions in the domestic contract for lump sum payments or for property transfers or designations of beneficiaries under insurance policies, all matters which the provincial court couldn't have dealt with under its own order in the first instance, then even though these provisions might clearly relate to support, and even though you spent a lot of time indicating and letting the director know, if you're considering the voluntary filing, that these do relate to support, they may not be enforceable. So in order to get around this dilemma, I'd suggest that if you're going for an uncontested divorce following the execution of the contract, it would be wise not to simply request the decree of divorce and then rely on that clause at the end of the separation agreement that if either party obtains a decree of divorce, the terms of this agreement shall continue and survive in force, but rather incorporate the relevant provisions into the divorce judgment. The fourth point to keep in mind is that the director will not interpret a terminating event where the event ending the support obligation isn't self-evident. One of the provincial court judges in Ontario has used the word self-destruct, a self-destruct clause. So where we receive an order which calls for support to terminate when the child is 21 and the child is 22, well, it's very obvious that the ongoing support terminates. That, of course, doesn't create a problem for anyone. But if child support is to end when the child is no longer a child of the marriage, for example, or if spousal support is to end when the wife lives with a man in a state resembling marriage, and there's debate as to whether or not those events have occurred, the director will not make that determination. And I think this is something that you should really keep in mind, and it's something that many debtors and creditors are very confused about. I can't get into it further than that, but I would ask that if you do have some more time, if you look at a very excellent article by Professor Keith Farquhar, his paper's at page 534, volume 64 of the Canadian Bar Review. It's titled Variation in Enforcement of Maintenance Orders Rattan Revisited. Also his Honor Judge Hamilton's decision in a case called Reniwick, R-E-N-I-E-W-I-C-K, 1986, 49 RFL 2nd at page 437. Those two matters will help you realize what kind of position both the provincial court presently is in as well as the director's office. Fifth, please take the time to include the commencement date and periodic payment dates in orders and contracts. Lots of orders and domestic contracts just say $600 monthly. Just take the time to say commencing November 1, 1987 and on the first of each and every month thereafter. Sixth, and this will seem very trite, please ensure that both parties have signed the domestic contract in the presence of witnesses. Okay, we've received quite a few contracts in that have not, where one or both signatures have not been witnessed, and Section 55 of the Family Law Act states that unless the domestic contract is in writing, signed by the parties, and witnessed, it's unenforceable. So just keep an eye out for that. The second area I'd like to cover is what further points you might keep in mind before sending clients to the director for enforcement of support provisions in domestic contracts or pre-proclamation orders. As Tom's indicated, these are the two cases, the two times that a voluntary filing is needed in all cases. Okay, first, keep in mind, please, that there are automatic termination dates for child support in the case of old orders made under the Deserted Wives and Children's Maintenance Act and the Family Law Reform Act. The ages are 16, 17, or 18, depending on the statute and the time that the order was made. It's disturbing to tell a creditor that's filed with us thinking that she's entitled to ongoing payments for, say, an 18-year-old, that she isn't. It's more disturbing when the debtor doesn't realize that either and has been making the ongoing payments and then indicates that perhaps he's entitled to a credit, and litigation has started all over again. At page C7 of the materials, the figure 18 at line 11.4 should read 17. That's the first figure 18 that appears at that point. The second point to consider as far as what you should think about before sending clients to voluntarily file is that domestic contracts must first be filed with the provincial court or the Unified Family Court under Section 35 of the Family Law Act, and then a copy of the agreement with the stamp showing the filing at the court can be filed with the director's office. Some lawyers seem to be under the wrong impression that if the domestic contract is filed after July 2nd, the court will automatically send a copy of that on to us. And that's simply not the case. It has to be voluntarily filed. Third, another matter to consider is that if there are pending enforcement proceedings which you've taken on your client's behalf or which your client has taken, and if there's a garnishment hearing or a default hearing that's already been scheduled, the director may not accept the filing until those proceedings to which the director isn't a party have been completed. Generally, the director will not adopt ongoing enforcement proceedings, and that really is the result of the exclusive authority to enforce and the parties and a combination of Section 5 and Section 2 of SCOE. Okay, what happens after filing? As we've said a number of times, but I think it's probably worth repeating, all orders before July 2, 1987 and all domestic contracts must be voluntarily filed. When the creditor is voluntarily filing, we need a copy of the order or the domestic contract with the provincial court stamp. As part of the filing process, the creditor will have to complete certain filing information forms. I think you've all received the white envelope saying filing package, and also swear a statement of arrears. It's important to either help your client or to explain to your client if they're talking to you about the filing process to break down those arrears. $18,000, I swear $18,000 is owing since June of 1980, won't do. So we need a breakdown of the amount of arrears because the creditor may well have to substantiate the amount of arrears down the line, and also we want to get as accurate a picture as possible in all cases with respect to quantum of arrears. After that's done, the creditor will receive a letter confirming the filing, that's at page C21, and the debtor will receive two letters which are at pages C22 and 23. One of those letters notifies him or her of the filing and requires all payments to be made to our office. And the second letter sets out the arrears, requests payment of the arrears and resumption of regular payments, and states that action will be taken if payment is not made. Now, in the case of post-proclamation orders, those will be automatically filed unless the person who started the proceeding serves the director with a notice not to enforce and files the notice with the court together with the order being issued and entered. So it's at the point the notice not to enforce should be sent or delivered to the director's office, then proof of service or an admission of service if it's delivered will be given, and the notice should be given with the original and your copy approved as to form and content, or if there was no representation on the other side, just the original and the copy for issuance and entry into the court. At that point, when that happens, the court won't automatically send us a copy of that order because they have the notice not to enforce. So I put a sample notice at page C24. Would you be able to hold your question until the end? Thanks. Okay, I put a sample at C24. If you can just delete the words quote or orders on the third line. It's a sample that I put in, but there were more than one order in this case, so it was an unusual situation. Okay, so each support order made on or after July 2, 1987 must contain the subsection 3.3 words, okay, in the operative part of the order as one of the paragraphs of the order. That needn't be ordered by the court. I mean, Master Court won't be saying, oh, and SCOE, put the SCOE provision in. He may or may not. But it's statutory. They're to be included, and they're to be included also in the case of orders which we're being requested not to enforce. So in all orders, in each order after July 2, 1987, interim, final. The only order that won't reflect that are provisional orders, provisional under the Reciprocal Enforcement Act, not provisional as an interim. Okay. Now, it should be perhaps apparent that for the program to work smoothly, it's incumbent on the party taking out the order to do so quickly. It's incumbent on the party being asked to approve a copy of the order, not to delay without some reason to delay. In other words, look at it quickly. If it looks okay, send it back quickly. If there's a problem and it needs to be settled, well, that's another matter altogether. Also, the payer's lawyer, we've been calling the payer the debtor. The debtor's lawyer should make sure that payments are made to the director unless there's a notice not to enforce, starting from the first payment due under the order. To make things probably more efficient, it would be a good idea if for the first couple of payments, the payer write the creditor's name on the back of the check, the date of the order, and probably the creditor's lawyer if that's possible, so that if there's a terrible delay, we have to get in touch with the creditor's lawyer to see what's holding up our receiving a copy of that order and opening a hard copy file on that particular case. Now, when the director receives an automatic filing, the lawyer whose name is on the back of the backing page will be contacted and asked to provide an address for the creditor. The creditor is then sent the filing package, and both parties receive a letter confirming the filing. In the case of either a voluntary filing or an automatic filing, where arrears have accrued, and where the debtor has problems with the amount alleged to be in arrears, he or she should contact the enforcement officer. Because the enforcement officers can act in the director's name, there will be a name of an enforcement officer at the bottom of the confirmation letters. The debtor should contact them. Generally, proof of payment will be requested by a certain date, and if received, that will be reviewed with the creditor. So, it's very important that the quantum of arrears be right first from the creditor's point of view, because remember, she's swearing a statement to that effect. But then if the debtor has a problem, if he says, I've paid, and I can give you the canceled check to prove it, then please, we'd like to see that. Okay, enforcement action itself will be determined on a case-by-case basis. Writs of seizure and sale will generally be issued in all cases following default. And then the practicality of garnishment, seizure and sale of assets, examinations in aid of execution, registration of support orders against the debtor's land, and default hearings will all be considered. In certain cases, the appointment of a receiver, a motion to restrain the wasting of assets, requests for a writ of possession, or a contempt order might be warranted. Those will be considered as well. Now, please keep in mind that the provincial court or the Unified Family Court continues to issue the writs and the notices of garnishment at the director's request. The director doesn't have the forms in the director's names. We're still requesting that the court issue those forms just as you've requested in enforcement files in the past. I'd ask that you review Provincial Court Rules 75 to 93 carefully, simply because we've been getting at the director's office a lot of disputes to notices of garnishment filed with us directly, and they're still filed with the court, the same way as they were in the past. In each case where wages are being garnished, our objective is to receive 50% of the net wages, and that's further to Section 7, Sub 3 of the Wages Act. It's also worth repeating what Tom has said earlier, that the regional solicitors for the program act for the director and not for each various creditor that's filed with us. So we will not be acting for creditors who may be required to respond to variation applications, and the debtor should therefore be careful to serve the material on the creditor and not simply serve it on the director and assume that the creditor will get notice of it necessarily, or assume that it's proper service, which it isn't. So please serve variation applications on the creditor directly. But again, as the director does control the enforcement proceedings after filing, if there's a request which may affect the enforcement proceedings, either coupled with the variation application or by separate motion, the director should be served as well. The fact that a variation has been requested won't necessarily cause the director to stop enforcement action. Until the original order is varied, enforcement will continue unless a court orders otherwise. And just to conclude, the director accepts uncertified and post-dated checks with respect to ongoing support payments, although that privilege is lost if any one of the checks is returned not honored. The payments are recorded on computer, and then the director issues a government check to the creditor in the amount received from the debtor. Thank you.
Okay, I would like to address my comments to the role of the lawyer in private practice for the creditor. I had been hopeful that after July 2nd of '87 that my collection practice would be restricted to my own accounts receivable, but as things are turning out, there is definitely an ongoing role for the lawyer to continue to represent his or her client in an enforcement proceeding. The point that I think sometimes gets lost is that, and it can't be overemphasized, is that the director does not act for your client. Okay, the director and SCOE, the lawyers for SCOE, are not your client's lawyers. You, unfortunately, in some cases, are still your client's lawyer, and there are a number of issues which will continue to arise in the interplay between what SCOE does and what the private bar does that will require your involvement. And I think as SCOE continues in existence and over time, those areas will become more clarified. I think right now we're finding out, perhaps on a case-by-case basis, where you're still going to be needed. So you have to bear in mind that the director does not act for your client, and I think there's going to be some confusion on behalf of your clients because they're going to go to court, they're going to see a lawyer there, they're going to see Linda or someone else, and they're going to perhaps think that this is their lawyer. So let's look at some of the decisions and issues that arise that you as a client's lawyer are going to have to address. I think one of the very first ones, and Linda has touched on it a bit, is if you have an old agreement or an old order before July 2nd, under what circumstances would you want to get into SCOE, particularly if you're not having particular problems collecting support? You have voluntary payments made is there still some reason why your client would file or would want to get into SCOE? I think there are a couple of advantages. I think probably they're quite obvious. One is that if the director is collecting the payments and remitting them to your client, then there is a record that has a presumption of accuracy. That's something that your client on her own or his own doesn't have. The second issue is, again, something that you and your client would have to discuss, which is I find in some cases that my female clients have to beg for the checks. They do get them, but they're forced into a situation where they beg for them. Some of my husband clients say, you know, I don't get the kids till I bring over the check. So there may be situations in which having this third party be in charge of collecting the checks and remitting them would lessen tensions between your clients. So I think in an appropriate case, that's an appropriate consideration. There are also disadvantages to getting involved with SCOE when you're getting ongoing payments and there hasn't been a default. Many people are quite offended at government involvement in their lives. Some people feel it's quite intrusive. So I think it's fair enough to discuss this with your client, and that's something that people have different opinions about. The second corollary to that is when you do become involved with a government agency, there's a certain loss of control, perhaps, that people feel. And this is something they have to keep in mind, so that prior to default, there may be many people who say, well, no, I'll just continue the way we've been. So with orders that are in the past, old orders before July 2nd, you don't have any real problem. You don't have to file them. There's no automatic filing. And with separation agreements or domestic contracts, if you don't voluntarily file, you don't have to get involved with this system unless you want. After July 2nd, if you don't want to get involved, you're going to have to file a withdrawal, a letter of withdrawal, or in the materials Linda prepared, there's a notice of withdrawal, and you should file that at the same time as your order is, as close in time as you can as your order is going to go to the program, just saying, here's the order, but don't do anything about it. If you have an order and there's been a default, are there advantages to going with SCOE or trying to do enforcement yourself? As I said, on July 2nd, I had hoped I'd just be able to hand my clients filing packages and close the door and say that's it. It doesn't appear that that's going to be possible for a lot of reasons. The advantages of using SCOE are quite obvious. You again have the presumption that the arrears are correct, and I think we've all been through that process of your client saying, well, I think he paid in January, but I don't really know, and you know, it's a pain in the neck trying to prove arrears. So you have a presumption of accuracy, which is useful. Plus, the most key thing, obviously, is that potentially there's no cost to your client. The government is going to undertake this enforcement. The government agency is going to pursue it, and that's of great utility to your clients, obviously. The third thing that SCOE potentially can do, I think, is Tom Wright talked about the additional sources of information, the type of thing that the director has potential access to without having to resort to motions to the court, which is stuff that the private bar would have to bring a motion to get, and that's potentially quite useful, that the director may be able to find out information and find out things about the debtor in a more timely fashion and pursue things. So is this really nirvana for collecting arrears? Is this really the best thing that's ever happened? I think it's a long way towards the best thing, but I think there are also some disadvantages and potential disadvantages to your client. The most obvious one to me, being in private practice, is simply this loss of control and loss of personalized attention. There's, I think, a great risk, or I shouldn't say great, I mean the program's been in effect for 3 or 4 months. There's a potential risk, I think, that your clients may fall between the cracks, that there may be some part of their case that SCOE can take care of and there may be some part of their case they can't. So there are some disadvantages that I think will become more clear as time goes on and hopefully be addressed by the program. I think one of the issues in terms of disadvantages is perhaps the potential for a lack of reporting, a lack of information to the client. We all know how tiresome it is to return phone calls where basically the client says what's happening, but we're on retainers or we're on legal aid or we do something, we have to return the calls. Again, because the client isn't represented by the director, I think there's a possibility that the client may not be kept as up to date as possible, and we all know what that means. They're going to be phoning us, and then we don't know anything, and then we have to phone SCOE. And I think there's a risk there that they may not get the same personalized attention in terms of information. And then on top of that, there's the whole range of things that SCOE won't do or can't do and isn't set up to do, and Linda's touched on some of them. I think the most, to start at the beginning where Linda did, she's gone through and itemized the type of orders that SCOE will enforce, the type of provisions they will enforce. So it's automatic that if you have an order that doesn't fall into one of those categories for whatever reason, then you're going to have to do private enforcement on behalf of your client. For example, the whole caveat that the order has to be enforceable by the provincial court. You may have an order from outside Canada or from outside Ontario that isn't subject to automatic reciprocal enforcement, and if that's the case, it's not something that SCOE is going to be able to enforce for your client. You're going to have to do that yourself. The second thing that arises almost automatically with many attempts to collect support, arrears of support, is applications for variation, either based on material change in quantum that is being requested or material change in termination. All these cases about proving whether the children have in fact withdrawn from parental control, who they're really living with, and so forth. That's something that comes up in many, many cases, and again, that's something that SCOE is not set up to deal with. So again, your client may start off with what is considered a normal routine enforcement, file the filing package, and then lo and behold, a variation materializes, and at that point, it's important that the client have independent representation to respond to that, whereas Linda's role or SCOE's role would still be to deal with the enforcement, which would have implications for applications for stays of garnishment, stays of enforcement proceedings, and so forth. There could, in fact, at that point in time, be two lawyers handling the same type of, the same case, only with different components to it. The other matter that Linda alluded to, and I think we shouldn't lose sight of, is that if our clients, or if we have already undertaken enforcement proceedings that are underway, we're not going to be able to just transfer our file over to SCOE. It's not the same as having your client retain other counsel. You're going to have to perhaps, although again it's subject to the discretion of the director, perhaps follow through with the enforcement process to a point where either a new order is made for enforcement or something is in place, but it's not automatic that SCOE is going to want to take over this dog's breakfast that you've been, hassling over for 18 months. This isn't a place to send all these files, which I was very disappointed about. The other issues, I think, again, that relate to perhaps the fact that this is a government agency. It's set up, and it's a good thing it's set up, but it's set up to handle a particular volume of cases and so forth. If you have a client who has a particularly difficult situation, I think you'd have to give considerable thought, if he or she had the means, to continuing enforcement process on your own. I think there's a risk that a case that involves something more than the steps that Linda described that SCOE automatically does, you might want to canvass with your client, assuming again that cost could be addressed, that you would handle it yourself. I'm thinking of cases where debtors may be cleaning out bank accounts and absconding from the province very quickly, cases of people who are running private companies where you want to appoint private receivers. Linda's mentioned this, but I think my concern as a private practitioner would be that perhaps because it's a government agency, there might not be the same ability to pursue more intensive processes. And again, that's something we'll find out over time, but I think at the outset, if your client has the means to address it, it's something that might be considered that you would hang on to. In a practical matter, there are a number of ways that we'll still be involved. I think the first one is that I think our clients are all going to keep phoning us to find out what's happening on their case or what's going on. And again, I think this could be a problem for them in the sense that we don't know any more than they do once the director's taking steps. So I think there'll be some issue with your client, maybe even just describing the process. They may call you and say, I have to be in court on this day, but I don't know what's going to happen. Hopefully when they attend in court, the solicitor for the program spends some time with them, and I know they do that, but I think we're going to be fielding calls like that, and I think we should be aware that that's likely to happen. The second thing is that the statement of arrears that has to be filed has to be prepared by the client for arrears prior to filing, and that may be something your client cannot do on his or her own. And that again may involve us getting our files out and going through it with them. The other matter that at this point the program can address, which carries on from that, is the calculation of interest. If your client wants to claim interest, that has to be calculated or in some way quantified by her or by you with her. Unfortunately, the program isn't set up at this point to calculate interest. And a further problem arises in that you should be aware that SCOE uses a particular formula for cost of living which may not exactly mesh with your order or with your separation agreement. In the Family Law Act, things that are filed for indexation under the Family Law Act use a cost of living year from November to November. You may do an agreement that's April to April or June to July or whatever, and if that's the case, you may have a bit of a discrepancy which needs to be addressed. And quite frankly, with the clients that I've had that do enforcement, I'm not sure they're going to be able to do this on their own, and unfortunately the program isn't going to do it at this point. So again, there's a lot of little bits and pieces of technical stuff that the client may have an expectation that somewhere along the line is going to get taken care of, and in fact it may not. And again, I think the other thing that's going to get us getting our old files out is if we get a call from SCOE saying you acted for Mrs. So-and-so for the last 15 years, can you describe her litigation, or do you have any financial statements from the husband or whatever? I think that that's likely going to happen, and I think we should be prepared to cooperate in that sense. But it's something we should be aware of, that it's going to be a time to us. As I say, my mentality was that I could stop taking these phone calls on July 2nd, and I'm obviously not going to be able to. The other decision that you have to help your client with potentially is when to get out of SCOE. Tom Wright was describing the case where if you have a client who's in receipt of public assistance, you have to get the consent of the minister to withdraw, and that seems to make sense and would have an impact on a client who was in receipt of public assistance. But if you have a client who's not, what kind of factors do you look at? What would be the things you'd be concerned about? And I think the thing to keep in your mind is that if potentially you may have a client who's dissatisfied with what's gone on. Either they don't get reported to, or they don't understand, or they have no money, and they just are fed up and they want out of it. Withdrawing from SCOE is not the same as having the file transferred from another lawyer to you, because again, you have to focus on the fact that the director doesn't act for your client. So there's some implications to that. One of them, I think, would be that if you do want to withdraw, then the proceedings that are filed on behalf of the director are not equivalent to proceedings you would want to file on behalf of your client, and they would not jibe together and would probably be discontinued or withdrawn or somehow canceled, which would mean, again, you're starting over in your own client's name, which if you then later on run into more and more hassles and it's costing her more and more money, and then you want to get back into SCOE, there's other implications for that. So I think you have to always keep that at the front of your mind. It's not just someone else doing your job. It's a much more different operation. I think the worst aspect of trying to advise a client when to withdraw from SCOE is the potential that you may not know what's going on or what has gone on. It may be difficult without going down to court and looking at the whole file. It may be difficult to find out in a timely way where the case is at and what's happening. And I think that would obviously have implications for your advice to a client. I think typically they may be dissatisfied about how long things are taking, about what steps have been taken, and typically they're not able to articulate to us in any terribly useful fashion what has gone on, and it may be difficult to find out from the director's office what in fact has been going on and why things are in that state. So that I think is a risk. Again, given the program's only been in practice a few months, I don't think we can say for sure this is what's going to happen, but I think, again, that's a potential risk that we have to address. Because I gave my comments out of order, I have come to the end. I didn't have anything else to add. Do you?
Thank you.
No? Okay.
I think it should just be pointed out that the presumption of accuracy happens only from the date of filing onwards. So the statement of arrears that the creditor is preparing continues to be very important. She might have to, get up there and quantify those arrears. I have the pleasure of introducing our next two speakers. Elisabeth Sachs of Dranoff and Associates in Toronto has practiced family law since being called to the bar in 1978, and she holds a BA in Political Science from Bishop's University and an LLB in BCL from McGill University in Montreal. For a number of years, she has been a seminar leader and marker in the Family Law section of the Bar Admission course and an executive member of the Family Law section of the Canadian Bar Association. She's participated regularly on CBA panels and programs and appears as a guest speaker for government, professional, and community groups. She is co-chair of the CBAO Annual Institute of Family Law, which will be held on February 6, 1988 in Toronto. And Michael J. Marra graduated from Osgood in 1979 and was called to the bar in 1981. He was a partner in the two-member firm of Smelko and Marra in Simcoe, that's not Barrie, but the Simcoe area, for 6 years, and he practiced primarily at that time in family law. Since May of 1987, he's been with the Attorney General's office with the Support and Custody Enforcement Branch. He's the regional solicitor for the Hamilton region.
Thanks, Linda. I'd like to thank Heather Robertson for not sending us any of her dog's breakfasts. We have received a few, however, one or two. I'm sure that most of you are here today to try and make some sense out of the mysterious ways that the Office of the Director is working and has been working for the past 3 months in relation to support enforcement. There is another aspect of the Director's duty under the Act, and that is in relation to custody enforcement. The same duty that's imposed in relation to support orders under Section 2, Sub 2 is imposed in relation to the enforcement of custody orders. The same discretion that's imposed or that's available under 2, Sub 2 that was discussed in relation to support orders also applies with respect to custody enforcement. That is, in relation to the method of enforcement, whether it's practical to enforce a custody order or not. Obviously, as you know, custody issues require a different approach to enforcement than that taken with respect to support issues. Unlike support enforcement, which has been described in some of the rounds that I've been making as seemingly very machine-like or automated, custody enforcement by its nature requires the exercise of judgment based on experience and skill as applied to the facts of an individual case. As each case has its own differences and peculiarities, it is difficult to draw a clear line or provide a distinctive statement as to the Director's approach to custody enforcement. Essentially, though, enforcing custody from the Director's point of view means enforcing in abduction-type situations or situations where it is apparent that the non-custodial parent has withheld the child contrary to the order without any intention or apparent intention of complying with the order. custody order is a defined term in Section 1, Sub 1 of the Act. Custody itself is not defined. What we're talking about, though, from the director's point of view when we talk about custody enforcement is physical care and control, as opposed to the other various incidents of custody. Out-of-province orders, because of the nature of the definition, must have first been recognized by an Ontario court pursuant to the recognition procedures that are available in the CLRA, specifically 42 sub 1. Similarly, in the case of out-of-province divorce orders which contain custody provisions, those orders must first be registered pursuant to Section 20 of the Divorce Act and Rule 70.25 prior to being enforceable within Ontario. As such, unlike private custody enforcement, the director has no jurisdiction to bring a combined application for recognition and an apprehension order. And that's something that the private bar will continue to carry on. Note that it has been mentioned today, we're not talking about access here at all. It's specifically in the definition that access is not included. Also in the definition, it includes separation agreements, and they can simply just be filed directly with the director's office for enforcement. The withdrawal provisions that have been discussed already in relation to support apply equally in relation to custody enforcement. It's important to note that there are no new specific remedies created by SCOE with respect to custody enforcement. As such, it is essentially the role of the director to perform the function of establishing links within the community with other agencies involved in custody violations and custody enforcement, and as well, particularly with the police, with a view to enforcing custody in a cooperative manner. When a violation or breach has occurred and the custody order has been filed in the director's office, the director will direct staff to utilize its locating resources, and those resources are considerable, in assistance with the police to attempt to locate the non-custodial parent and the child. The director's role, in addition to the liaison with the police, will be essentially to obtain an apprehension order under Section 37 of the CLRA. An apprehension order, as you know, is an order which specifically directs the police to locate, apprehend, and deliver up the named child in the order to the person who's entitled to custody. This kind of role that we have taken as a result of the statute is exhibited in relation to, or is nicely exhibited in relation to a case that occurred in our region in Hamilton. There was a parent abduction from a recreational facility that the custodial parent became aware of in the mid part of an afternoon this summer. The parent, obviously frantic, contacted his own lawyer. It was a father who had custody in this particular case. He contacted his lawyer, shot down, and got his original custody order. He was advised to contact the police. He went down to the police station, wanders in there to the front desk, and he's referred to the family court. Takes his custody order and goes over to the family court. Goes in, staff wonder, what do we do? Fortunately, there's duty counsel. Their court's still on. They refer him to duty counsel. Duty counsel goes, SCOE, sends him over to SCOE. And we're there to fill that gap that seems to have existed previously. That's a big part of our role. Immediately, that custodial parent, who at that point in time was completely buzzed, he was just totally frantic, he got into my office, we started on it, and within 2 hours, we were starting on our function. He was into the back door, basically, with the police, and the following morning we had our apprehension order, and within 2 days the child was returned. So we're there to fill that kind of void that seems to have existed in the past. I'm sure if he hadn't have got steered over to SCOE at that point, he would have been back on his lawyer's doorstep, and it would have gone completely full circle in a matter of 2 hours. When a custody enforcement issue arises, within the regional offices, it's been designated that it's the regional solicitor's responsibility to conduct that initial interview and meet with the custodial parent in a very comprehensive fashion in an attempt to get all of the material facts down. There's a couple of reasons for this. Obviously, we're attempting to try and determine, based on some experience, as to what the true nature of the problem is. Is it an abduction? Is it the case where it's an access dispute that has maybe gotten out of hand? Each case depends on its own set of facts and the history. In cases arising out of the regional office, the regional solicitor would contact the panel lawyer who's closest to the residence of the custodial parent and attempt to arrange for the custodial parent to meet with that panel lawyer to carry out this kind of interview and carry it forward depending upon his or her assessment of the situation. There's a checklist of questions in the materials that we have developed to be used as a starting point in an initial interview such as this, with a view to determining the true nature of the problem. And it's kind of handy whether you're a panel lawyer or whether you're carrying on your own private practice in relation to this kind of issue. It's important from the director's point of view, to really evaluate facts for 2 reasons. Firstly, the regional offices have established a relationship with the police, and the police presume that if they are contacted by our staff in relation to a custody matter, they will presume that we've conducted an extensive interview already. And they won't send out, in most cases, a uniformed officer to take an initial report and put the custodial parent all through that whole process. Once again, they'll send an actual criminal investigation officer, who would be the officer responsible for that investigation, over to meet with the custodial parent, or else meet that custodial parent when he or she attended at the police department. So they'll presume that we've already done the initial questioning and that it's a legitimate case for them to be serious about. And that's important. It speeds up the process. There's some credibility there already once the custodial parent goes over to the police station. The second reason for a very detailed questioning is the fact that if we bring an apprehension application, it's going to be based on an affidavit that's sworn by that custodial parent. Probably the application is going to be without notice, and you're all aware of the obligations that you have to the court as counsel to ensure that full and fair disclosure is made in an affidavit where it's filed in support of a motion without notice. From the director's point of view, because the director is there to ensure compliance with court orders in the interests of the whole system of administration of justice, we're particularly concerned that full and complete disclosure is made out in that affidavit. We're not there as an advocate on behalf of the custodial parent to advance his or her interests to the fullest. We're there on behalf of the director to ensure the compliance with the court order. So we really question and really attempt to spend time in getting all the facts, all the relevant material from the custodial parent so that it can go into that affidavit. In the typical custody enforcement situation, and I'll just use an abduction kind of situation as the model. After that initial interview, and it's a legitimate case for enforcement and for the director to act, I would contact, or one of the enforcement officers would contact the criminal investigation section, wherever the contact was at the local police, and arrange for the custodial parent to meet with that officer, taking with him or her the certified copy of the custody order, and maybe just give a little bit of background over the phone to the officer. At that time, then the regional solicitor or panel lawyer, if it was a panel lawyer situation, would start on preparing the material for the apprehension order. If it was a clear abduction situation, our enforcement staff would immediately start on the locating function that they can carry out. Once the apprehension order is obtained, certified copies supplied to the police and to the enforcement staff. The police are asked to put it on the CPIC system, and they do. Sometimes they will do that simply based on the custody order. It depends on the circumstances. And what I do is I ask the police in that initial contact if they can put it on the CPIC system if there's a concern over concern of a run by the parent. Certainly once the apprehension order is obtained, the police will enter it on the CPIC system. Our enforcement staff, as a matter of routine, will alert the Border Patrol, Airport Security, U.S. Customs, essentially as standard procedures or precautions that are taken. In addition to that, our enforcement staff, and I can tell you that the investigative aspect of the director's office can't be underemphasized. I'm really impressed with the investigative background that the enforcement officers have within the director's office. They've got considerable investigative experience, and I'm continually amazed at how they can track down people that haven't been heard of for some period of time. They use that experience and expertise, and it's buttressed by the remedies such as Section 6 that's available. And I suggest that in all likelihood the use of Section 6 will be more, and as against solicitors, I know the prospects are such that could cause some nightmares and some real catch-22 feelings, but custody situations is the primary area where I think that Section 6 will be used in relation to the solicitor if it is used in relation to solicitors. Certainly the computer resources that the director has in the office in relation to MTC link-up, OHIP information, the federal data that's coming upon the proclamation of the Family Orders Agreements Enforcement Assistance Act, and other investigative tools that the director's office has really provides a valuable service that really hasn't existed previously. In a case where there's been an abduction that the whereabouts of the parent and child is not known, our staff will carry out an investigation similar to that the police carry out in terms of using these resources with a view to it assisting the police in their investigation if they're carrying out an ongoing investigation as well. Those are that represents the conclusion of my comments, and I'll turn it over to Elisabeth for her views on custody enforcement.
Good afternoon. I've been asked to address the practicalities of custody enforcement, and Michael very kindly has covered a lot of those, and I know it's close to coffee break, so I'll keep my comments brief. The paper that is found in your materials, starting at Section E, basically outlines what are the existing remedies and methods to go about in a custody enforcement. One thing that I would like to stress that's very apparent when you review SCOE, there are two things actually. One, SCOE does not create any new remedies or any new methods of conducting a custody enforcement in any way. All the old methods that we're used to, using the statutes, the Children's Law Reform Act, and so on, the Criminal Code, the Habeas Corpus Act, are not in any way affected by SCOE. Secondly, there is a very strange definition of custody in SCOE. It is inaccurate and it is wrong in that it refers to custody provisions contained in marriage contracts and cohabitation agreements. Under the Family Law Act, those provisions are void. So if for some reason you have a strange-looking marriage contract, perhaps even from another jurisdiction, or a cohabitation contract that deals with custody, nothing in SCOE is going to help you. You can't enforce that kind of provision. You should also note that custody as defined in SCOE is simply the bald word custody. Custody is defined in different ways. Under the Divorce Act, the new Divorce Act, it includes any incidence of custody. So you have a wording problem immediately when you start looking at agreements or orders, even when they're Ontario agreements or Ontario orders. I think the one thing that assists us all in SCOE, and that is the information gathering power of the director. That is something that we used to have to do on our own. These are non-legal functions. It depended on who you knew. Did you know your local police enforcement group, the youth bureaus? Who do you know at the Border Patrol? Do you have the numbers for airport security? All those things can be taken over by the director's office. The problem with that information gathering power is its impact on us. We've heard a number of times this afternoon that there is no common law rule of confidentiality. There is nothing protecting us from the director when a demand is made on us. I would suggest that as far as the whereabouts of my client are concerned, his or her address, place of employment, that is not information that I am going to voluntarily divulge. I would expect that the director will take me to court to find that out. And notwithstanding the fact that the director may get a court order and, in the words of the statute, shall be awarded the costs of that particular motion, I think this is one of those cases where you can ask the court to grant costs of $1 if it's going to grant costs at all. I think our function as solicitors and our ethics with respect to confidentiality are more important than simply a section in a statute saying you will divulge this information about your client. That's a difficult thing to say in custody enforcement because we are all on the same side. We are not adversaries of the director. We all want the same thing. We want orderly arrangements for children. We want what's in the best interest of children, and none of us are really advocating that children be abducted or removed when there are orders or agreements in place. You should note that there must be an order or agreement in place before SCOE becomes involved. If you're contacted by a parent and there is an abduction situation where there has been no court action, there has been no agreement, clearly you are the first line in terms of not only getting an interim custody order, but also in obtaining those apprehension and location orders if they're necessary as part of your initiating material. I think that the private bar is much more crucial in custody enforcement than it is in the support area. Firstly, as Michael briefly mentioned, any foreign order, and that means any order emanating from outside of Ontario, must first be recognized in Ontario. Now, the director won't do this, and it creates sort of an unusual situation. It's one paragraph in your order, normally, in your apprehension order, and it may, in fact, be a few minutes of submissions. So you might get the strange situation where you are there, retained privately by the client, to obtain one paragraph of an order and make 3 minutes of submissions, and the lawyer for the director is there making the rest of the submissions. This arises out of the office's role as an enforcer, as opposed to a determiner of issues. The court is called upon to determine the validity, perhaps, of the foreign order, or whether it's something that can be enforced here, so therefore the director just doesn't take over that function. The Children's Law Reform Act doesn't have any enforcement provisions in it, and that's why you really get this double initial representation to a court. The most important thing, I think, from the point of view of the private practitioner now, is what are you trying to enforce? The function of the director is discretionary. The magic words custody and access, as we traditionally know them, are something that we can all understand. However, that is not normally, in fact, in many cases now, not normally the way we are wording our separation agreements or even court orders. There's a lot of the shared parenting, a lot of the care and control 1 week to one parent, weekends to another parent, who in fact has custody of this child. What the director might have to determine initially, as you would if retained privately, is this an overholding situation? Is this an abduction? Is this simply an extension of access? Is this a denial of custodial rights? Is this a division of the incidents of custody which in fact are justified under the agreement or the order that you have? And if the director cannot determine what it is that's going on, then there simply will not be enforcement through SCOE, and it will be the private bar that does enforcement in whatever way it can. Another point is that filing of custody agreements certainly is voluntary. In terms of orders, as was mentioned under the support discussion, the custody provisions in an order will not be automatically enforced. That must be a separate request, even though the order is sitting there. One of the other problems that arises out of what is happening to the child is that, as Michael mentioned, the director would like to investigate before taking steps and sort of taking this file on as to what is happening. This takes time, and time is the one thing you normally don't have in a custody enforcement situation. Even a space of a few hours might mean that the child is out of the jurisdiction, maybe in another country, and basically no matter what order you get here, no matter what piece of paper you have, it isn't going to help you very much. These things generally don't happen between 9 and 5, and they normally don't happen on Monday to Friday either. That way, the private practitioner is going to be involved first, as opposed to perhaps the regional solicitor in the SCOE office. I would like you to just take a quick look at the precedents that are contained at page E22 and E28. The affidavit that is in support of the notice of motion, you'll note, is a little bit unusual. This involved a restraining order that was granted by a foreign court. There was no custody order in place. And so the notice of motion, in fact, asked for custody of the child, not just an apprehension. In that kind of situation, of course, you will be the lawyer who prepares the material and appears. The director would not be involved. Similarly, the order that was granted did not just recognize the foreign order, but in addition granted a custody order here in Ontario. It's that order, certified copy of that order, that you would then take down to the director's office. In fact, you could step out of the picture at that point, and the director would in fact take over with the custody order. The problem with that, again, is you're coordinating yourselves. When you deal on behalf of a custodial parent who's got an apprehension order, you should have planned in advance the getaway, the actual apprehension. You should have done the liaison with the police department or whoever else is enforcing the order, and to duplicate that may be difficult. If you do not know where the child is, then this is where the director's office becomes absolutely vital, because as Michael mentioned, they have the resources and we as private practitioners do not generally have them. A third and perhaps final concern that I have is with respect to custody apprehension orders being obtained without notice. And I believe it is a policy of the director's office that to wherever possible act in situations where it is a no-notice urgent situation. It's done without notice for the usual obvious reasons. These motions can be, as set out in the materials, made before an action is even commenced, and all you have is your notice of motion and your affidavit material. If you know where the child is, if you know where the holding parent or person is, if you do not have any concrete and real reasons to believe that the other person will run with the child, I'm going to suggest to you that a court will ask you to do this on notice. Once it's done on notice, of course, the holding parent has all the defenses and all the issues that can be raised about the best interests of the child that are outlined in the paper, and what you are getting into is an action on the merits. At that point, the director will step out, and the client, again, will be in the position of dealing with a private practitioner at full cost, as opposed to dealing with the director's office. Where there's a clear abduction, where there's a clear urgency, the director's office will act. However, if the defenses are raised, if the validity of the order or agreement is called into question, the director just can't act. This goes back to the idea that the director is not the solicitor for the client. The other concern, of course, is once you get into court, once there are questions raised as to what is going on with the child, who will appear on the motion to set aside the enforcement? Not the director. Who will argue the validity of your agreement or order? Not the director. What if the child, as sometimes happens, gets his or her own counsel and disputes the enforcement? Again, the director is in a very difficult position and will step out. This whole issue of custody enforcement seems to be sort of stuck in at the last minute in this act. There is no equivalent in Canada to this kind of enforcement provision. Anywhere else you have to retain private counsel. Finally, what a court might do will effectively oust the director's jurisdiction. For example, make interim orders, stay the application. It is not the director's function to continue with an action on behalf of the child. It is simply there to enforce. I think what we should be doing with SCOE and with the director's office and its resources is to use the state machinery. It's there for us to use. It's free. They have access to data banks that we could never hope to get. When the new federal act is proclaimed in force, you and I, to obtain the same information, must make a court application that the director can obtain simply by, I guess, picking up the telephone or dialing it in the computer. The liaison with police forces and other enforcement agencies, I've always found that if you have the state saying, here we are, and we'd like to liaise with you, that has much more power and effect than you getting on the phone and saying, I'd like you to help me enforce my custody order. The vast network of support staff that the director has, all free of charge, with their expertise, is something that we can't hope to duplicate. So although we can't look to the director to do our custody enforcement work for us in the fullest sense, they really are an adjunct service, a liaison service, an assistance to the kind of work we do, and basically are not to be seen as our adversaries. I think for that we can be thankful. It may even save our clients some money at some point in time, and most importantly, I think in terms of this kind of enforcement work, it does make our jobs a lot easier. Thank you.
I think it's